大家好，我是秦苏珊律师。那今天的话呢，我会跟我们的团队去讨论一下 Bia 上诉。那现在在川普的统治下，打庭的速度变得非常的快。就像三塔安娜这边法庭，现在大家都知道，如果说你住在就是洛杉矶以东的地区，如果你的案子是划分在三塔安娜法庭的话呢，你的小庭到大庭的时间基本上是6个月的时间。那你大庭没有过的话怎么办？你如果说30天内不上诉到 Bia， 你就会有递减令。那如果说你上诉到 Bia 的话呢，那么可能有几个月、几年的时间去等待这个结果。那现在监狱里面打庭的速度也很快。那也就是说，现在有越来越多的案子需要上诉到 Bia。那 Bia 到底是怎样的一个流程？那通过率又是多少呢？所以现在我会跟我们的团队去讨论一下。Hey Craig, hey Judge Ham.
Hi, how are you?
I'm good, thank you. So I was talking to my clients the other day. We have a lot of questions from our Chinese community. They're asking questions like, why are cases moving so fast, especially in Orange County, Santa Ana court, and some other courts as well. Somebody's interview didn't get granted, so the case get referred to EOIR, and then they have within a month they get a master's hearing, and then within 3 to 6 months they get a merits hearing set up. So it's pretty fast, and of course, they wanted to know, let's say, if they don't get the individual hearing granted, for the BIA appeal. So most of the questions I get is, what are the chances that the case will be remanded back? So I'm going to start with Judge Ham. So let's say somebody appeals to BIA. What's the procedure? What's the success rate?
All right. The appeal process is rather simple. After an adverse decision or a denial, the person has 30 days from the date of the decision to file a notice of appeal. Now, that notice of appeal only requires that the person identify what issues that they're concerned with in the judge's adverse decision. After that, a transcript of the proceedings, a hearing transcript, is created from the digital audio recording of the hearing, and that's provided to the parties with a briefing schedule. The respondent or the person that is appealing, the appellant, is given usually about 30 days to file their appeal brief, and then the government has 30 days to file its opposition. And then thereafter, the board will make a determination. Now, I think with the current administration's desire to try and deport as many people as possible, there have been shortcuts that have been taken by the courts and by the government. And I think these are issues that are ripe for appeal and can be a basis to remand the case back to the judge for further finding. Now, I think our office has been very successful with that in the last few months, in which we were able to get at least 2 cases remanded, and 1 case looked by the board for additional evidence. But I think with the expedited processing of these cases now, mistakes are being made, and these mistakes can be the basis to have the case remanded back to the court for a further and new hearing. So especially in this very draconian and very enforcement-prone agency in trying to get people deported, I think the appeal process is a way of slowing down that process and getting a better and a fairer determination of someone's case.
Yeah, so we've had a lot of cases lately. Last week it was really busy. On Tuesday we had 9 hearings. We had so many masters, and we had I think 2 bond hearings and 1 individual hearing. So that was crazy. So Craig, I know you've taken a lot of detained cases. These cases, they move so fast. Can you tell us what's going on? What's the situation with the detained cases? How fast are they actually moving?
Yeah, so I think part of this administration, what they're trying to do is make it really difficult for people to claim asylum, and also make it difficult for people to appeal their cases. Judges are now looking for the smallest things to challenge someone's credibility in order to deny their asylum application. And if the judge denies their asylum application, they'll try to discourage the person from appealing their decision, even though they're appealable issues. And part of the way they're trying to discourage people to appeal is saying, well, you can appeal, but you're going to be detained for 3 months while your appeal is pending. And some people don't want to remain in detention for 3 months while their appeal is pending, and other people say, well, I don't want to appeal, just send me back home because the conditions are so unbearable that I don't want to wait. And they're also trying to discourage people from appealing by imposing a new fee to appeal. I think it's about $1,010. So they're saying, well, you have the right to appeal, but you can be still in detention, and now you have to pay over $1,000 to appeal. And this is just a way to discourage people from appealing, because there are a lot of appealable issues. And as we've seen with Judge Hung, who's been very successful with granting winning cases on appeal, that we can win on appeal. It's just understanding that the government's now putting in additional hurdles to try to discourage you from appealing. Now, if you're not detained, it's always advantageous, to reserve your right to appeal, because it just delays any enforcement. Like, you can't be remanded or removed from this country while your appeal is pending. And so, if you are not detained and your application is denied, we always reserve your right to appeal, and then encourage the appeal process to go forward. And it just costs $1,000 in administrative fees to do that appeal. And so that I think is still worth it. But if you are detained, be prepared that you could still remain in detention for a few months while that appeal process is ongoing.
And you brought some very good issues here and some good points. You're right. One, the fee issue. They raised from 110 for BIA appeal. That amount, for years. I think for 20 some years it was 110, and then recently it became $1,010. That has increased quite a bit. And unfortunately, a lot of our detained clients, once they lose at the merits hearing, they give up. One, it's because money. It's a lot of money, and then two, they don't know how long they're going to be detained, waiting for the outcome. And like you said, the conditions unbearable. Sometimes they just give up. They said, okay, you can detain me to a third country, or you can send me back. And then when they do get sent back home, they either have to pay a fine or detain for a month, but they are willing to risk this. So Judge Hum, with BIA appeal, I know in the past sometimes it takes 5-6 years to get a result, but lately we've seen with BIA appeals we actually get a result within 3 months. But then other BIA appeals, they have been pending for a year, 2 years, 3 years. So it seems so random. Is it like now with so many cases? So many respondents appeal their cases to BIA. Does BIA have the capacity to handle the cases, or is there like a pattern how long it's going to take to get the briefing schedule?
Well, the pattern used to be for a non-detained case, it would take anywhere between 7 to 10 months for a determination to come out of the board. For a detained case, it's usually 3 to 4, maybe 5 months, because as the person is being detained, the government's paying $350 a day for that detained person to have them detained, to feed them, to house them, provide medical services and what have you. But the government wants those cases decided as quickly as possible. So there is a priority with detained cases. Now, what you've indicated is a recent phenomenon in which certain cases are being prioritized by the department. And they take a look at the merits of the case, and if they feel that case has really no merit, they want that case prioritized by the board for a decision, so now they can go ahead and try and meet their quota of deporting 1 million people in a year. So I think this all comes down to the current administration's desire to fulfill a campaign promise and step over and rake over the due process rights of individuals in these immigration proceedings. And if he ever tried this with the criminal bar, he wouldn't get away with it. But with the immigration situation, since it comes under the administration, the Department of Justice, he's permitted, and he feels that he has impunity to do whatever he wants with the immigration situation. He's getting rid of judges that don't agree with him. He's creating detained facilities in horrible environmental conditions, and he's with a budget that had passed for him, he now has a sizable income of money to build one of the largest enforcement forces, the ICE, in the United States, far exceeding the police department and some law enforcement organizations in the United States. So all this goes to this campaign promise of trying to get people out of the country, people of color, people who do not agree with him politically, or don't agree with him even on an ideology level, that they're different in color, they're different in language, they're different in customs. He wants a certain type of America, and this is how he's going to do it.
Talking about judges, I remember Craig and I had a conversation last week about 100 some new judges were being appointed last week, but not by the Department of Justice. They were military attorneys, right? So Craig, can you tell us about what's going on with that?
Yeah, I mean, the Trump administration fired a whole bunch of immigration judges, and now they're trying to fill that backlog with military judges who, serve under the commander-in-chief of this country and, take orders and directions from this administration. So, clearly a conflict of interest. And also, they don't have the proper training. But I think they're just giving this directive to adjudicate more cases because there's a massive backlog, because of all these judges being fired, and because of the administration's now desire to expedite numerous cases. It's definitely concerning about the lack of due process that's going on right now for a lot of these cases, and the bias that's going on right now in processing these applications, which is why a lot of cases are appealable, because there are going to be a lot of errors in these cases. And judges, again, like I mentioned before, they're going to find the smallest little thing to challenge someone's credibility to deny their application, and because they're under orders to deny applications.